Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 19th, 2026. We are on voting list number 11, and we are going to start off with Senate Bill 661.
Thank you, Mr. Chair. Senate Bill 661, this bill is back from voting session yesterday. There's a new amendment in your voting packet. This is SB 661/643/622/1. It's part of the packet that was just passed out by staff. What this does is it addresses the criminal piece of the wiretap statute as well as the admissibility piece. If you turn to page 2 of the reprint, you'll see language at C12. It is lawful under this subtitle for a person to intercept a wire, oral, or electronic communication that is a recording of or is part of a recording of the commission or attempted commission of the following crimes against the person: murder in any degree, rape in any degree, or assault in the first degree that is a domestically related crime as defined in 6-233 of the Criminal Procedure Article. It is an affirmative defense to a criminal prosecution under the subtitle that the defendant intercepted the wire, oral, or electronic communication because the defendant reasonably believed that the defendant was in imminent danger of becoming the victim of a crime listed in subparagraph 1 of this paragraph. And then following on to the, let's see, it'll be bill page 2 of 3 of the reprint. You'll see some crossed out language. There's new language that would provide any wire, oral, or electronic communication that has been intercepted is authorized under 10402C12 of this subtitle, which is the language that I just read, may be received in evidence in a criminal trial or hearing before the district court or circuit court if the communication, 1, is a recording or part of a recording of the commission or attempted commission of a crime listed in 10402C12 of the subtitle, and is used as evidence in the charge of an offense listed in 10402C12. A communication described in paragraph 1 of this subsection may not be admitted as evidence of a crime not listed in subsection C12. Going on to the next page, language about notice to the defendant would remain the same. And then, as discussed yesterday, there would be language that would provide this section may not be construed to abrogate or limit any rule relating to the admissibility of evidence under the Maryland rules.
All right. So motion's been moved. It's been seconded. Everyone is okay with adopting the amendment. Everyone understands what the amendment does. Hold on. All right. No, honestly, no, real talk. Does everyone understand what we're doing here? Okay.
I have a question after.
Yeah, sure. Senator West, go ahead.
I just want to compliment the committee chair and the staff for responding to the concerns expressed yesterday afternoon. And that's, I think, what this committee does so well. We simply don't roll them as originally drafted. We try to work out bugs that are identified by members of the committee. We did that in this case. We worked creatively. We worked hard. And this is the result. Congratulations all.
Thank you, Mr. Chair. I just wanted to kind of echo those Senator West's comments and thank the committee staff. I want to thank the chair, the bill sponsor. I mean, there was a lot of dynamics. There's a lot of layers to this, and I think we worked through for a really good final product. And I'm glad to see that, you know, we all came together to make it as best for the victims moving forward. So I appreciate that. Thank you.
I agree with my colleagues. I think it's good for those who have been victimized in this manner, and I hope that my colleague, when we go to the floor tonight, won't be coming and victimizing other victims of fair housing violations.
I agree with everything that was said here today so far, and I appreciate the work that council does, and I appreciate Senator Folden for, this is vastly superior language than we've had, and it hits on all the notes that we wanted it to hit on. I don't want to slow this down, but in creating this language, we struck some language from the previous version of the bill that I thought was all agreed upon, separate from the part that was controversial. So we struck from the bill that the evidence has to be, that the interception was not made in furtherance of an investigation on behalf of law enforcement officials in the state. That was non-controversial. We struck the contents of the communication and evidence derived from the communication are more probative on the point for which they are offered than any other evidence that the proponent can procure through reasonable efforts. That part was not controversial. And we struck the interest of justice will best be served by the admission into evidence of the contents of the communication and evidence derived from the communication. That part was also non-controversial. So I think in drafting the new bill with its vastly superior language, we accidentally may have dropped language that was non-controversial from the previous bill that I think was likely necessary to effectuate what the original sponsor and Senator Folden wanted in the bill.
Thank you, Mr. Chair. Good points, Mr. Vice Chair. My only thought is for all of the parts on the admission, I don't know that they're necessary now. I think it was when we were focusing only on the helping the evidence get introduced, and that's why I have it. We had it. It's still going to be subject to, all the rules of evidence as we go forward. So I'm not sure that we need that part. The law enforcement part, not subject to law enforcement, I'm fine with that as well. And I'm not sure we need that other language, but I'm certainly not opposed to it.
So in light of what Senator West and Senator Folden has said, I'm a little disappointed because I had contacted ABC and submitted a TV show called Dysfunctional Families, State Government Committee Style, and now I have to withdraw that request. I was going to make TV stars out of all of you.
I'm just so touched that all of us can support Folden, that all of us can support Folden for the first time. Oh, I'm sorry, I said this real fast. I'm so surprised and I'm thankful that everybody could support Folden's amendment. I'm very thankful. I don't even know what it's about, but I feel good, okay? That's all I want to say.
Amen.
Amen. Amen, there you go.
I'm not going to make this longer. I echo what Senator Folden and Senator West said. I'm just so impressed and so appreciative of the work. But I also wanted to make just a brief comment on the Vice Chairman. My understanding is, not to the first sentence, I'll get to that, but the latter two, that is the standard by which evidence is always admitted or not. And that's imbued in our courts and judicial proceedings and in all the rules about whether it's probative or not, whether it's prejudice or not, and all that sort of stuff. To me, that was superfluous language. It may have been put in when we had other dynamics in the bill. So that's just my thought about that, and you can certainly follow up and check me on that. And on the latter, or the first point about law enforcement, I think that too is a bit superfluous. It's sort of like you could put that in any statute you wanted to say, if you do this, make sure we make it explicit you weren't helping law enforcement. And I'm just not sure. If you have some cases or some doctrine that contradicts what I'm saying, I don't think that is necessary, as I think it's sort of jumping the gun a little bit. But especially on the others, I think that's imbued and embedded in all aspects of when evidence comes in, those factors are weighed. So just want to make that comment.
I do think there's some value in the vice chairman's comments about the language that was struck. I do also think there's value in my colleagues' comments about the parts that speak to admissibility as it relates to relevance and that probative versus prejudicial balancing test that the court does. But the part that relates to the conversation or the police not wanting to make sure that we don't circumvent getting a warrant and being able to allow the standard that we have in place for law enforcement to remain in place for law enforcement, and this not circumventing that standard for law enforcement. I think that part was really important, and I think we had that there intentionally for some very good reasons. So if there's an appetite, I think it's very important to restore that. We don't want people to go to seek help and then for law enforcement to say, well, it's just much easier if you just put this recording device in your home, because if I do it, I have to get a warrant or XYZ. We want to be able to keep those guardrails in place so that we keep the integrity in those processes there while we create this exception for these limited circumstances. And having said that, I do appreciate the care of the committee and of council in making sure that as we protect the privacy of intimate communications, that we do have what looks like a limited set of circumstances where we are trying to strike a balance for some of those most harmful and egregious conduct, where we can give people the benefit of the opportunity to capture more evidence so that they can prosecute these sort of crimes and offenses. So I do appreciate the care and attention that it sounds like all of the feedback from our dialogue was incorporated into these amendments. So I do appreciate that.
Thank you, Mr. Chair. So I just want to be very clear. If this bill passes and becomes law, we're not going to see law enforcement, directing someone to tape themselves being raped. What you're going to see is law enforcement advising them that for their own safety, that they're allowed under these very finite circumstances to not be a felon, to record for their own safety. We made it very, very tailored and narrow in scope. And so, I think the bill, we've spent a lot of time on this. I think we've made it very sound, very solid, and I think that anything about trying to infer or make that somehow law enforcement's going to use this as an opportunity to get around the wiretap rules is not something that this body should be concerned about, because law enforcement has an obligation to make people aware of functioning within the scope of the law, that there will be now provisions to protect victims from being victimized, from being re-victimized, from continuing. So if by law enforcement advising someone what's going to be legally within their scope of response or for safeguards, that's not telling them to go and get around getting a judge's consent. That's the individual making the decision at that time later to be able to have evidence there or to be able to record to protect themselves. So with that, I would like to move the bill as it's with this amendment, and with this amendment, also I would then like to add a second one for additional sponsor and with the amendment. As it would be. So thank you.
I just want to be clear, no one, and certainly not me, is saying that law enforcement would instruct people to record their own rape. That is not what I'm saying. We had it in the original amendment to the bill because we respect the duty that law enforcement has. We respect the sophistication of a law enforcement investigation, and we respect the sophistication of when they intercept and what they do and how it's different than a civilian. And we certainly want to preserve the integrity of that process, and we want to preserve the weight of that evidence when it comes into court. It's different than if a person is recording their own evidence, and we want there to be differentiation. We want to be able to uphold that to the standard that we ask judges and juries to look at when law enforcement is intercepting communication. We don't want those two things to be blurred. We want them to be very different and discrete. So if this law makes it clear that law enforcement intercepts are different than a civilian, then we want them to have that distinction. And I think we put that in there intentionally because we do respect our law enforcement, and we want to be able to continue to do that.
Thank you, Mr. Chair. I appreciate this dialogue, and like everyone, I really, really appreciate all the work that was put in. I do think that was in when the bill was in a different posture and a much broader posture, when it was crime against an individual, which was much broader. And so I really don't think it's necessary when we have this very narrow, very targeted bill. So I would second the motion to move the bill as amended.
I think what's being referenced is the balancing test that's under 5403 of the Maryland rules, which provides evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury, or by considerations of undue delay, waste of time, needless presentation of cumulative evidence. With the language in the bill, it's similar, but the language in the bill provides the contents of the communication and evidence derived from the communication are more probative on the point for which they are offered than any other evidence that the proponent can procure through reasonable efforts. So it's not so much the relevancy balancing test, it is saying that basically this is the most probative and on-point evidence to prove the facts of the case than anything else.
Yeah, that's hard to do. All right.
Vice Chair Waldstreicher.
On the amendment or the amendment?
We have amended the bill. It's on the bill as amended.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
Yes, and if I can explain real quick, wasn't inferring that I want to apologize. I don't want you to think that I was trying to say that that police would direct to record a rape or anything of that nature. I do feel, and I appreciate the dialogue. I do appreciate it. This bill is just such an important bill for victims, and it's an opportunity that, as ironclad as we can, we've worked a lot of different angles of language to make it as narrow but protective of these victims as we can, and I really do. I think we made a good product, but I really do appreciate the dialogue, and thank you for expressing your concerns. So hopefully it wasn't meant that you were inferring that, so I just want to be clear. Thank you.
Senator James.
I'm all for it, but are we going to have another chance to be co-sponsored now that I love this bill? Or is that it? It's okay. If we don't, if that's going to make it complicated, we don't have to.
It's not going to complicate anything. Motion to reconsider the half vote.
Is that okay?
Pass this, then
So we go,
So now there's, who would like to be amended onto the bill? Senator,
no, we're going to vote again with this additional amendment.
Senator-
Do you want to be on it? Well, then raise your hand, or you're on it.
James, Senator Folden, Senator Muse, Senator West, Sidnor.
Okay, so everybody is on it.
You say yes or no? Yeah.
Everybody is on it except for James and Folden.
Okay.
So just for drafting purposes, was there anybody who didn't want to be on the bill?
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
So I'm a yes, and I'll just rip up that application for ABC.
Senator Charles.
Yes.
Chairman Smith.
Yes, Senate Bill 661 with the amendments passes unanimously. All right, here we go. One thing, all right, two-party consent, been two-party consent been very protective of the statute over the years. We've let two exceptions slide this year, but I will say this right now to all the advocates and people listening, do not bring another bill next year. Do not bring another bill for the two-party consent while I'm chair of this committee, because it's not going to happen. All right, so let's be very clear on that. Do not even bring the bill. Okay. All right. That's quashed right there, right now. And they will go right in this drawer. All right.
We could have a kill calendar.
Or we can just have a kill calendar, that's fine. All right. Let us go on to Senate Bill 524.
Senate Bill 524 authorizes access to and confidential use of a juvenile police record and court record by specified entities within the Baltimore City Mayor's office if the office is providing programs and services to a child who is the subject of the record for a purpose relevant to the provision of the programs and services or the development of a comprehensive treatment plan. There is an amendment in your packet. It's number 803-522/1. The amendment requires the mayor's office to have a memorandum of understanding with the Department of Juvenile Services and written consent from the parent or guardian of the juvenile before accessing any records. Just for context around the amendment, my understanding is the mayor's office and the Department of Juvenile Services are in agreement on the amendment.
So just for council, this was a pre-existing practice that the statute just left as like a reinitiation of this practice, is that right?
Correct. A similar statute was in place but recently sunsetted, and this institutes not the identical statute, but a functionally similar statute.
All right, so we need to adopt the amendment.
Yeah.
Sorry, motion to adopt the amendment, and then we'll have discussion on the amendment. Is everyone okay? Adopt the amendment? All right. Senator Folden.
Just trying to ask for clarity here, because, so this bill will allow the mayor's office for certain programs to do a background check or to check their, I'm just curious. I'm trying to clarify.
It's access to the juvenile records for purpose of diversionary programs they have for juveniles.
So DJS will share this information with service providers so that they can better serve the youth that are enrolled in these programs. It's a program, a practice that's been underway for I don't know how many years.
I understand.
Yeah.
I just, and it said as long as did it say as long as someone was okay with it, like the family member or the juvenile?
Yeah, so first there would, under the amendment, there would need to be an MOU between the department and the mayor's office, and then they would need written consent from the parent or guardian.
Okay, thank you. Perfect.
All right, now the bill's before you as amended. The motions were favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. All right, Senate Bill 524 with the amendment passes unanimously. We're going to go to Shamari with Senate Bill 651.
Senate Bill 651 establishes the Maryland Transfer on Death Act in state law. The bill includes provisions relating to 1, the elements, recordation, and effects of a transfer on death deed, 2, revocation of a transfer on death deed, 3, the effect of a transferor's death, forms and informational documents for transfer on death deeds, 5, exemption of transfer on death deeds from recordation and transfer taxes, and 6, interpretation and enforcement of the bill. The bill applies to any transfer on death deed made before, on, or after the bill's effective date by a transferor who dies on or after the bill's effective date. There is an amendment in your packet. That's amendment number 993-924/1. Amendment number 1 is technical. Amendment number 2 provides that a transfer on death deed that designates multiple beneficiaries may transfer ownership of the property to the beneficiaries under any form of tenancy indicated on the transfer of death deed. And if the transfer on death deed does not indicate a form of tenancy, title shall be conveyed to the designated beneficiaries on the death of the owner, or if multiple, on the death of the last surviving owner as joint tenants with right of survivorship. 2, it adds advisement to the statutory form recommending consultation with the lawyer if there are name changes since the property was acquired, or the transfer wants to name multiple people in the deed. And it adds additional questions to the common questions section of the statutory form. And it permits a beneficiary to file in the land records a transfer on death deed notification of death form, and provides another statutory form in the bill.
All right, motion to just to adopt the amendment, seconded. Is everyone okay with adopting the amendment? All right, now the bill's before you as amended. Senator James.
This bill, and I'm hoping you'll let me co-sponsor it with you. This is something that I've been interested in for a long time. I'm just thrilled that you brought it up and got this bill before us. Thank you. So if I can do that. No, I mean, no.
Thank you, Mr. Chair. I'm happy also to join as a co-sponsor of the bill if we're doing an amendment. So my question is, I'm looking at the testimony. The Maryland Land Title Association had favorable with amendments. Does this amendment reflect the suggestion of the Maryland Land Title Association? It does. Oh, fine. Oh, this is great. Thank you.
Thank you.
All right, I have James, West, Smith, Love, Kenny, Hughes. Seymour.
Folden. Folden.
All right, now the bill's before you as amended. Is motions for a favorable? It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 651 with the amendments passes unanimously. We can do one more, and then we'll go to 202. Senate Bill 937.
Senate Bill 937 generally establishes certain restrictions on a landlord's use of a prospective tenant's criminal history records, in addition to other prohibitions. Among other provisions, the bill also reduces from 7 to 3 years the applicable period of criminal history included in a reusable tenant screening report, and 2, mandates the data collection and annual publication of related complaint information by the Office of the Attorney General. Violation of the bill is an unfair, abusive, or deceptive trade practice under the Maryland Consumer Protection Act and generally subject to MCPA's enforcement and civil penalty provisions. A violator is subject to a maximum $1,000 civil fine. So there is an amendment in your packet. That's Amendment 543722/1. And so Amendment number 1 is technical. Amendment number 2 applies the bill to a landlord that manages 4 or more residential units. It permits a landlord, before extending a conditional offer, to require information on whether a prospective tenant has been convicted of listed offenses. It adds whether they've been subject to a registration requirement under a state or federal sex offender registration statute. It replaces the Office of the Attorney General data keeping requirements and adds the Office of Landlord-Tenant Affairs. It removes the civil penalty for violation of the subtitle. And finally, it permits a landlord, after a conditional offer has been made, to consider convictions listed in the bill under 8202A-05. That should read 05 on page 6 of the reprint. And referring back, the convictions that may be considered: a sexual offense under Title III, Subtitle III, child pornography under 11-207, and if the conviction occurred within 10 years immediately preceding the rental application, murder in the first degree under 2-201, murder in the second degree under 2-204, or human trafficking under 3-1102, and that's only if the prospective tenant has failed to disclose those convictions. It also permits any felony conviction under the criminal law article if the conviction occurred within 3 years immediately preceding the rental application.
Adopt the amendment and then work off of the amended bill. Is everyone okay with that? All right. Hold on one second. We're gonna go to Senator James first.
Oh, you mentioned sexual, various crimes. Is rape and
It's included.
regardless of the many degrees it can come in and sexual assault, is that what you just listed in one of those?
Yes.
The first one?
That's, they
sec-
can consider that before offering a conditional offer. And then if they fail to disclose that, then when they run the criminal background check after extending the conditional offer, they can then consider that.
Yeah, I just think I missed it because you listed a bunch of them, but
Yeah.
we don't call it rape, we clean it up and call it sexual violence.
It's listed under the subtitle.
Oh, subtitle.
Yes.
Okay, thank you. Thank you.
Senator Henson, we were doing so good. So there was a lot being read there, Shamari. I just wanted to clarify. So we struck out all these other offenses on the reprint, right?
So are you looking at page 6?
Yes.
Yes. And so this is after the extension of conditional offer.
After the extension of conditional offer.
We struck those offenses, but the amendment on lines 15, it refers back to the convictions that can be considered before the conditional offer. And so if a
Only
tenant
if
fails
they,
to disclose.
only if they didn't disclose it.
Correct.
Okay. And then I know there was something in that was mentioned, and I was trying to follow it as you read it, but about like registered sex offenders or those type of issues?
Yes. That's on page 5 of the reprints.
Okay.
And so before extending a conditional offer,
Okay.
a landlord may require information on and may reject the prospective tenant on the grounds of whether the
Gotcha. Okay,
tenant
so
has
we
ever
didn't
been
do any,
subject.
that was just a slight modification of the,
Well, that amendment seems to encompass other state registration requirements and federal state sex offender registration.
so we're still allowing them to make a decision based on if someone's a sexual predator?
Yes.
Okay, cool. Awesome. Okay, that's what I wanted to touch base on. Thank you.
Here. So just moments ago, I went out into the lobby and was given, the landlord community gave me a marked up copy of the bill with some suggested amendments. They said they've been trying to get these through to me, but for whatever reason weren't able to get them through in the last couple of days. I'm just reading them for the first time. I think some of these amendments sound good. The violation section, the current violation at the end, for example, provides, since it covers Title 13, a commercial law article, said would subject a landlord to a fine of up to $10,000 for the first offense, up to $25,000. They want to tail that back. It seems to me reasonable to tail that back. That's a huge amount of money to fine a landlord. So I wonder if we could hold this so I could go over these amendments with the committee leadership and staff and see whether there's an appetite to accept any of these amendments rather than pass the bill right now.
Shamari, correct me if I'm wrong, the civil penalties that appear on the last page, we struck the penalties out, right?
Correct. That's stricken from the bill, and it
Yeah.
just refers back to the,
Is there anything else there, Senator West? We struck the penalties out.
Well, it says the violation of this subtitle is an unfair, abusive, or deceptive trade practice within the meaning of Title 13 of the commercial law article. And what they say is that, please note that a violation of Title 13 would subject a landlord to a fine of up to $10,000 for the first offense, up to $25,000 for a subsequent offense. So there are about 6 different suggested amendments here, and it's hard in a committee of the whole to discuss 6 possible amendments. I've just seen these things. So it seems to me it's reasonable to.
No, and I've been working, this is, I think, the 3rd or 4th year that this bill has been introduced, and my office is always available and always open to working on amendments. I'd be happy to take a look at these and maybe put it at the end of our voting list, but I don't want to hold this bill any further. Thank you. Thank you.
I will take a second to take a look at these if I can, Mr. Chair, but I don't want to hold the bill for another vote.
Session.
All right, so we're going to hold, the bill has been amended in this before, we're going to hold it until the end of the calendar and move on to something else. All right, so now we're going to go on to Senate Bill 202, which you're going to have to look it up on your laptop. It's admitted. Senate Bill 202.
Jamie's going to have them and going to share them with us.
So Senate Bill 202 authorizes a police officer who is denied a right granted by the laws relating to police accountability and discipline to apply at any time before a hearing is held by a hearing board to the circuit court for an order that directs the law enforcement agency to show cause why the right should not be granted. The police officer must make the application to the circuit court of a county in which the law enforcement agency is located if the police officer is an employee of a county-wide or a local law enforcement agency, and to the circuit court for Anne Arundel County if the police officer is an employee of a statewide or bi-county law enforcement agency. There is an amendment that has been proposed. At this time, it's not in official amendment form, but was provided shortly ago. It would strike the language of the bill and instead add language to Section 3-110 of the Public Safety article, which pertains to rights that police officers have in disciplinary proceedings, and would provide that a police officer who is denied a right granted by the police discipline subtitle, which may not be remedied by a trial board convened under 3106 of the subtitle. So trial boards are the adjudication body in police disciplinary matters, may apply to the circuit court for an order that directs the law enforcement agency to show cause why the right should not be granted. So my read of that is that, and Senator Fulton, correct me if I'm wrong, if it can't be remedied.
Turn that into like just regular language.
Right.
And why the separation from the trial board is important.
It's a separation from trial board because that would infer that there was some type of non-compliant or violation of policy procedure, whereas this language would not be covered if it was an incident that's not covered by a trial board, so something outside of disciplinary, that they would have the show cause to, yeah, for like whistleblower protection, for all these other things, it would allow for that. I don't know if you want to have Frank, if he wants to talk to it real quick.
Yeah.
Yeah.
Yes.
Yeah, Mr. Chair, members of the committee, I'm Frank Boston on behalf of the Fraternal Order, Maryland Fraternal Order of Police. Yes, the bill is originally drafted, applied to show cause, which is kind of like an interlocutory appeal to all proceedings, including disciplinary proceedings. And I think that some of the concerns that were expressed was we don't want to delay the disciplinary proceedings that are a part of the trial board process. So we said, understood, because they already go to the administrative law judge anyway. But things that don't go to the administrative law judge and that are not a part of the statute 3113, which applies to trial boards, all of these other protections, there's no remedy for in an immediate show cause hearing. Examples: whistleblower, secondary employment, you're not supporting the political affiliation of your boss, and then you know, all of a sudden you get demoted or you get hours you don't want. And there's actually a section, section 3110, which is entitled Rights of a Police Officers. And it says, you know, police officer may not be discharged, disciplined, demoted, et cetera, reassign, transfer, or deny promotion in regards to the police employments because the police officer, one, disclosed information that shows evidence of mismanagement, waste of government resources, i.e. whistleblowing. And it goes on in the statute to talk about, they can't be disciplined for lawfully exercising their constitutional rights. So everything that is not disciplinary, there's actually a statute where this language fits perfectly. And it basically says that if these rights in this part of the statute are violated, this non-disciplinary part of the statute violated, you don't have to wait 2 years for a trial. You can say, hey, wait a minute, let's have a show cause hearing on it.
No, I think, just wanted to make sure that was on the record, because if it were within the realm of the disciplinary process in the trial boards, that's a different conversation altogether, just given, the work that this committee's done in years past. So I just want to make sure that that was on the record. To my mind, this actually incentivizes, good behavior and accountability. So I will happily support the bill as amended.
Good. Any questions?
All right, we can move the amendment. Now the bill is before you as amended. Senator Sidnor.
And thank you. I just want to make certain that I'm understanding the rights that are being spoken about is limited to mismanagement, a waste of government resources, a danger to public health or safety, or a violation of law or policy committed by another officer. And then I'll go to, then I know it's one more, lawfully exercise constitutional rights. So is that correct? Counsel? Who's what, Frank?
You got it. Yeah, you can
Yes, Senator Sidnor, that's correct. That's why I was put in that section.
All right. And under to lawfully exercise constitutional rights, what does that encompass?
Yeah, that's the intent of it.
No, I'm saying, what does that encompass? That's a
constitutional right, freedom of speech, your right to take on secondary employment. I don't know if that's a constitutional right, but any normal constitutional rights that any individual would have, or you would have.
Okay, I'm trying to take it all in.
Yep.
All right, so go ahead. Council's going to read that section of the statute into the record.
To 3110, the lead-in language would read, a police officer who is denied a right granted by this section and which may not be remedied by a trial board convened under 3106 may apply to the circuit court for an order that directs the law enforcement agency to show cause why the right should not be granted. Okay.
Yeah.
All right.
We specifically want to point out this, anything that's not covered by a trial board, because that was the concern. Yep.
There's an motion for a favorable on the amended bill. It's been seconded. Do we need a roll call? Roll call. Okay, yeah, 100%.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
I'll pass.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
Yes.
Senator James.
Yes.
Senator Henson.
Yeah.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Senator Sidnor.
I'm going to vote no for the moment and see what until I understand.
Chairman Smith.
Yes. All right, Senate. All right, Jamie, you ready for Senate Bill 464?
Yeah.
Senate Bill 464.
Uh, 464, Senator. Senate Bill 464 establishes the Commission to examine the expungement laws of Maryland. To be staffed by the Governor's Office of Crime Prevention and Policy, the Commission must examine the state's expungement laws and current expungement process under Title 10, Subtitle 1 of the Criminal Procedure Article. It must review comparable expungement laws and processes in other states and develop an alternate statutory scheme that provides a streamlined process and broader eligibility. The Commission must submit a report of its findings and recommendations to the General Assembly by December 31st, 2027, and the bill takes effect June 1st, 2026. There are 2 amendments in your voting packet. Those are in the smaller packet that was passed out just shortly before voting. The first in your voting packet is Amendment SB 464. It's Senate Bill 464, Senator. /903225/1. This amendment would add a representative of a law enforcement agency of the state to the commission. Yes. Just looking at this one, because there is an additional amendment that addresses the same subject, there's an amendment just behind that one, which is 863627/1, and that would add, let's see, 1, 2, 3, 4 representatives. 1 representative of the Maryland Chiefs of Police Association, 1 of the Maryland Sheriff's Association, 1 of the Maryland Crime Victims Resource Center, and 1 of the Maryland Network Against Domestic Violence. It would also extend the work of the commission. It would push out its report to December 31st, 2028, and would push out the effective date until 2029. Oh, sorry, it wouldn't actually become effective, it wouldn't take effect until 27, and then it would sunset in 29.
Jeff's out here.
I just wanted to say I'm happy that this is one of the few bipartisan bills that everyone seems to support here and on the floor, and I'm just grateful for all your love and that we're going to move this forward. That's it.
All right, is everyone okay with the amendment? Okay. Okay, Senator Folden, you had, okay, never mind. Okay, okay. Yeah. All right, now the bill's before you as amended. Motions for favorable with the amendment. Is everyone okay being recorded in the affirmative? All right. Sorry, yep, 1 second.
Senator Muse, you're going to be on it? I thought that was the rule. No, I meant on the worker. I thought that was the rule.
Yeah, it is. He covers a member of the Senate and clerk.
Yeah. Yeah, many agencies. Got a lot of agencies.
Oh, yes.
Okay, so I have West, Smith, Henson, Sidnor. Okay. Love. Okay, anybody else? Arnold? One striker. Oh, is anybody not want to be on it? Great.
No, she said who doesn't want to be on it?
Yeah. Everybody?
Senate Bill 335.
Oh, I'm up. I just not responding. I'm sorry, I missed that part. I apologize.
Come on, we're gonna, it is, we're gonna overwhelm.
Senate Bill 335 prohibits, except as authorized under federal law, a landlord or residential rental property that uses financial information as part of a prospective tenant's rental application from refusing to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy on the basis of the prospective tenant's income, credit score, lack of credit score, or adverse credit history as specified. The bill establishes such an action as a discriminatory housing practice subject to enforcement by the Maryland Commission on Civil Rights. A landlord that receives funding from a governmental entity, a quasi-governmental entity, or a nonprofit organization that requires income qualifications for tenants in income-restricted rental units may collect financial information from a prospective tenant if the collection of such information is a condition of the funding. There is an amendment in your packet. It's amendments. Give me 1 second. 593728. And that amendment prohibits a landlord from using adverse credit history if it arose during a period when the tenant didn't have an income-based housing subsidy, if the period that they didn't have the subsidy is confirmed by the applicant, voucher paperwork, documents provided by a housing authority or a public housing authority in response to a request by a landlord. It prohibits a landlord from requiring that a public housing authority verify dates of housing subsidy for purposes of assessing tenants' credit history. It permits a landlord to require verification of income for rent not covered by the subsidy using a ratio substantially equivalent to what's used for other tenants. And it permits a landlord to refuse to rent to a tenant on basis of any commercially reasonable and non-discriminatory use of a reference from a previous or current landlord or tenant's history of violating leases, creating a nuisance, or damaging property. The last part of the amendment requires that certain landlords offer the option of having positive rental payment history reported to a consumer reporting agency.
All right, now the bills before you as amended. Senator McKay.
Jamari, how does this actually work in the real world?
So I think the intent is that when a a tenant applies with the housing subsidy, that the landlord is only going to consider the history, adverse history while they had the housing subsidy and not the time before, because once they have the subsidy, they're presumably able to meet higher rent requirements. And so I think that's basically the intent.
How does that actually work? I mean, I understand where we're going to have multi-housing corporations that'll have somebody who's been educated to exactly understand what you can and what you can't. But for the smaller organizations, how are they going to be able to put this in practice? It just doesn't seem like a boat that can float.
Well,
We have somebody here who can answer that.
Thank you, Mr. Chairman, members of the committee. Emily Helver-Mail with the Baltimore Regional Housing Partnership. Thank you for the question, Senator McKay. In practice, any landlord of any size could use a commercial screening method that is customizable, that does not include a credit score in it and does include the credit history. Anyone can request a credit history report. So just to make clear the differentiation that we're talking about, the credit history report is the list of the adverse credit events, right? You can run that report. You can get it from Experian right now. Anyone can get a credit history report. You can check that and just verify again that it's during the period of time, not during the time when they had the subsidy, or, you know, that you're not looking at the time when they didn't have the subsidy.
So any of these websites or third party, they're going to now have a toggle switch for state of Maryland?
Many of these products are already customizable that are on the marketplace.
State of Maryland? I mean, I hear what you're saying.
For any landlord who wishes to use them, many of them are customizable currently. But again, you also don't have to use these third-party screening. You can use landlord references. You can continue to use unshielded records on case search to verify non-payment of rent issues. You can do a rental history check.
Okay.
There are other ways to verify this information.
Okay, thank you for your answer.
Of course.
Thank you. Shamari, one of the things that we said in here, what was the last part that you said something about establishing for good?
Positive rental payment history. So
that's not going to be like a website? Is that a?
So it requires the tenant or the landlord to give the tenant the option to have the landlord report positive rental payments history to a consumer agency.
To be clear, that cost gets passed on to the tenant, or
Yes.
can be passed on to the tenant if they choose to enroll in that optional service.
Right.
Yeah.
So, but if we're going to pass this with that in there, does that mean that this committee is now going to endorse positive reporting of rental payments? Or positive, right? So, and what I'm trying to get at is, we had a bill, I believe, last year that we did not allow to happen when it came to police officers on having positive reports about their conduct. And that was actually in this committee. I thought we didn't allow that to happen. So I'm just wondering, are we now in a committee that might be interested? I know that's not this bill, but if we're going to have the opportunity for landlords to be posting positive things about said public, I would certainly believe that this committee would maybe entertain in a future bill that when it came to police officers, and if you wanted to report good conduct that happened, which would then be in their files forever, as well as anybody making an issue with a problem.
I couldn't agree with you. I mean, look, I think this is a great thing, a tool that should be used, especially for folks that don't have an opportunity otherwise to build credit. It's a great opportunity, especially if you've lived in rental housing for a prolonged period of time. That should count it should inure to your benefit. But for the other, and these are completely disconnected, but I get the theme that you're employing here. I think, I was supportive of that initiative, and I think we passed that one year out of this committee.
I thought that part was stricken from it.
Yeah.
I
Senator James.
just want to clarify one thing. as I recall the testimony, even if you have a subsidy, and I think that when they're really generous, they go up to, it's like 70% of the rent could be, or maybe 80, what is it?
I'm not sure
It's a
the
big
exact
number.
numbers.
Let's say,
yeah.
but nothing in this bill means the landlord cannot look at the portion that the tenant would be required to come up with themselves without a subsidy and look at that rental, that ability to pay that 10, 15, or 30%.
Correct. The landlord can still screen for the portion of the rent.
And I am a
utilities not
landlord, and
covered
I'm
by.
a little landlord, and I don't do any of this big stuff, but I do know how to do credit histories on my own, and I know how to get criminal histories done, and I wouldn't know how to comply with this bill if my life depended on it, nor do I think I have access to doing that. So I think that you have to explain to me how you're gonna force me to follow this, when I'm just gonna look at what I need to look at, because everybody that I rent to lives right next door to me. So it's not like I'm a distant landlord, and I want to find out how everybody's doing. I want to know what the criminal history is. I want to know whether they are able to pay. I have children. I have all kinds of people that I need to keep safe on my very isolated farm. So I don't read this bill that you could compel me to do a lot of this. You know, you've got ideas that I can borrow software and do things like that. But if realistically, I don't know how to do this, and I don't want to spend money to figure it out, I don't believe that I got to be able to look at what I think is important, right? So, but if I'm wrong, you know, if I'm a little landlord and I rent 1 or 2 places, or even 4, that's a rhetorical question, don't worry about it.
That we raised about the size.
Oh, that's right, I thought it was, I thought we made it 6 or more, that would be.
That was a different bill.
Air conditioning.
I'm sorry, what was that?
We did air conditioning up to 10. 10.
We got to make it larger too, because little people like me don't, we're just trying to help our neighbors have a place to live. I'm not going to run out of business for this.
What was the question? I'm sorry. So we want to add? Not to this bill, there wasn't. But there is for the positive rental payment history, only applying to 6 or more.
Yeah, but I mean, for the positive rental history, why would we put a 6-unit exemption on that?
I believe that was from the law that this was drafted from. I think it was from the California Civil Code.
Exemption should be not on that, but should be on, if you're going to do an exemption, I mean, I'm just saying, like, it shouldn't be on that, because that's a positive thing. You should be able to offer that product to anyone. But
6. Shouldn't need the bills.
If it's positive, it should not have any exemption. I agree wholeheartedly. If there is actually a unit like, and similar to maybe it's what we did with the air conditioning, 10 or more, the exemption would be 10 or less that you don't have to. Mary Delaney? 10, like what we did with the air conditioning? At least that would be consistent with what we did yesterday. I think yesterday.
I think we should have a policy about exemptions, and I don't think we should have anything in here without considering. I'm good with whatever looks consistent. 6,
Well,
10.
the reason I said 10 was because we were consistent at least a day ago with 10.
Remember that we have those kind of exemptions.
So for 10 or 6?
no, just for the positive rental history, which is now cabined to 6 or more, just nothing, just exempt that. I mean, no exemption, just it should be offered by everybody.
And nothing,
No, what's the second part, sorry?
the second part is 10 units, the exception, 10 or less.
So this is,
I don't know how it works practical. I heard the answer from the advocate. I heard the advocate give an answer that I can pick and choose on how I'm going to be able to, I don't know how somebody who's a small landlord who's going to be able to navigate, and unless the third-party software says, this is what works in the state of Maryland.
Are you talking about for the checks and things like that?
Yeah.
Okay.
I don't know how you make that work.
On not advocacy, but just explanation. Yeah.
I understand the distinction. I did just want to raise that the existing fair housing discrimination law that exists in Maryland has an exception already in the larger code for small landlords. I do just want to raise that already the entire code that this is going into under the fair housing law discrimination has an existing, it only applies to, I believe, I'm sure the council can correct me, landlords above 5 units, I believe is what the council can confirm. So just to clarify that. I did also want to clarify in terms of the process and how this will work. So just to be really explicit, if a small landlord is having difficulty identifying when the subsidy began, they don't have to do that adverse credit history component doesn't apply to them at all. So the way that it's written right now, that component of not looking at adverse credit history during the period of time before they were assisted only applies if one of those permissible ways that they can determine the start of the subsidy, if that applies. So if they don't know, if they can't figure it out, if they can't figure out when the subsidy started, they can look at the entire adverse credit history, like from forever, from including the time when they're subsidized. So I just want to be clear about that too, that
Yeah, but then how does that work? Then there's no need for the bill. Because if I can't figure out when the time of what was the subsidy and what wasn't the subsidy, but I can look at it the whole time, then what's the purpose of the bill?
Well, it still has the credit score component to it that, again, we're not allowing the looking at credit score because it's not predictive, because it does bake in all of that past experience. That's kind of the distinction between the credit score versus the adverse credit history. So you still can't look at a credit score. That would still be a part of the bill. You can't look at the adverse credit history if you know when the subsidy started. And then you can't look at income beyond what is their tenant portion. So that's what the bill would do.
So that's my only my heartburn so far, because there's been a disconnect in what people are saying. And so I'm going to have both sides come up and talk about this, because I don't want just one sole source. So what, if you add utilities, some people are saying that it's already incorporated in the voucher amount. Okay, and then I think there's a counter narrative out there. So I'd just like to get clarity on that issue.
Yes, and it's regulation. It's federal regulation that the housing choice vouchers need to account for gross housing costs for the month. That includes utilities. It's very explicit that it includes tenant-paid utilities. There is a specific allowance. Every public housing authority uses the models that are derived from HUD to determine the utility allowance for any tenant-paid portion. They're based on local rates. They're assessed as part of the affordability that a participant pays, and a public housing authority can't actually approve a rent for a place that doesn't have the affordability there for the utilities.
So when it comes to the utility part of it, that can be broken down, because sometimes you can have a voucher that'll include gas if it's your heat source is hot water, but doesn't include the electric part, and then that should be subject to the credit. So you can't just say utilities as a whole.
What is outlined in the regulations are utilities that are consistent with what is in the general area, so includes water, sewer, trash collection. Utilities include electricity. I'm not sure what wouldn't be included. I must misunderstood your question.
As an example, I do have people that will get vouchers that will handle the heat part of the utilities, but does not include the electric, because the heat is basically included in the rent and that kind of stuff. So how do we sever the two?
Right, so that's what I'm explaining is included already in the calculations of what is considered affordable. Of course.
Thank you.
Yes.
So the bill does allow a landlord to consider the ability of the tenant to pay rent plus utilities. And so if the tenant has a voucher for 500 and the rent plus utilities is 1,000, the landlord is able to consider, all right, this tenant has to pay that $500, which includes the additional rent in addition to the utilities. That's different in this amendment than the version that passed in the House. So that allowance for the landlord to consider that is in the
I
bill.
understand that that's part of it, but I understand that it's part of it, but the overall that you can't then you look at the utility, if the gas part is in it because it's part of the rent, but yet then you can't look at the electric bill?
You can. You can.
Okay.
Rent and utilities. Now,
All right, so have we adopted these amendments? We have, right? All right. All right. Do you have a motion?
favorable is amended.
Is that including the amendment on the positive?
Yeah. Just for all units? Yeah.
Just
He made that interlinear. You made that interlinear.
I made the inline. I'll just say what I did. Okay.
I trust you.
And then as to the rest of the bill,
You were a yellow linebacker, you wouldn't lie.
oh, okay.
Question for council. It was testified earlier that you can still run the credit report on the delta. In other words, if someone's rent is $1,000 and the voucher is for $800, they can run a traditional credit score to see if that person can afford the delta. I don't see that in the text, and I'm trying to find that. So can you point me to that?
So this is page 2 of the reprint at the bottom. Notwithstanding subsection B of this section, a landlord or residential rental property may require verification that a tenant has sufficient income to pay the portion of rent and utilities not covered by the income-based housing subsidy using an income to tenant's portion of rent ratio that is substantially equivalent to the ratio used by the landlord for non-subsidized tenants.
Traditional credit score. Or it does not.
My interpretation is that if that's what's used for other tenants, I think probably. It doesn't say it explicitly, though.
Okay.
Yeah.
Okay. That's helpful. Thank you.
I think there's a little typo in the amendment you just read. Shouldn't it be the top sentence, a landlord for or of residential property? Not-
Yes, that should be of.
What?
That should be of.
Should be of?
Yes.
Okay. So you'll make that change?
Yes.
And above, correct?
I believe that's the case, yes.
All right. So there's been a motion for favorable, it's been seconded. We can do a roll call.
Vice Chair Watstricker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
What are we voting? The amendment? Are we voting on the bill or amendment?
Senator James,
The bill, not amendments, right?
the bill, yes.
Okay, no.
Senator Henson,
Yes.
Senator Love,
Yes.
Senator McKay,
Nay.
Senator Charles,
Yes.
Senator Folden,
I'm glad I said pass. No, I almost said yes.
I said it for you.
Thank you. Thank you.
Chairman Smith.
Yes. Senate Bill 483.
Senate Bill 483 requires the Judiciary and Department of Public Safety and Correctional Services to expunge all cases meeting specified criteria by July 1st, 2028, and newly eligible cases on a monthly basis thereafter. Under the bill, expunge means to remove all references to a specified criminal case from the central repository within DPSCS and remove from public view all electronic court records relating to the case without needing to redact physical or electronic documents, recordings, or audio or visual media. There is one amendment in your voting packet. This is also in the smaller packet that was passed out just before voting. This would strike provisions of the bill, and instead, if you turn to page 3 of the reprint, would provide instead that it would provide a definition for technically eligible for expungement, which would mean that based on the nature of a charge or conviction and the relevant time that has elapsed, a person would be eligible to file a petition for expungement under subtitle 1 of this title, which is the expungement subtitle, and would provide that on or before July 1st, 2028, the judiciary shall shield all cases in which all charges in the case are technically eligible for expungement. And beginning August 1st, 2028, the judiciary shall once per month identify all cases in which all charges in the case are newly technically eligible for expungement. And when within 1 month of identifying a case under that paragraph, the judiciary shall shield the case. Now, under the bill, it uses an existing definition of shielding, which would mean to render a court record and police record relating to a conviction of a crime inaccessible by members of the public.
All right, the amendment's been moved and seconded. Discussion on the bill. Senator Fulton.
483, right? Yeah. Okay, so as I'm looking at the reprint, Jamie, we've struck out a couple pages or almost, and we're just left with A, B, and C on page 3 of the reprint.
And there is some existing language at the beginning that's definitional.
Yeah, that's not going to be a part of concern for its definitions. But my question is, if you shield specifically in section C of the final page of the reprint,
right?
When we're talking about that they'll do it once per month in cases in which all charges in the case are newly technically eligible for expungement.
Right.
So can you explain to me what newly technically means?
Sure. So under the expungement subtitle, there are certain offenses that are eligible for expungement. There are also certain times that things become eligible for expungement. So after a certain period of time, your conviction for assault, I believe, now takes 5 years after final disposition to become eligible for a petition. Now, there are other steps involved in that.
So it's going to be under the technical, I guess, specifications of time and.
Right. So as long as you meet both categories where the offense is eligible and the amount of time necessary to file a petition is eligible, then that would be technical eligibility.
Okay. And then does this address when I'm looking at it and about if you shield the record, then how will people know how to actually expunge it?
So that was that.
Go ahead, Jamie. I'm sorry.
So in fact, the judiciary actually raised a similar question, and their position on it was, and I don't want to misquote anybody, but some of their staff had raised the issue that if the records were not publicly visible, somebody who would otherwise maybe file a petition for expungement may not know that they needed to, or may not know the information necessary to file that petition for expungement.
So could that then serve as a detriment to the person trying to, like, they could be inadvertently negatively impacted by this as worded, because they would, so general public wouldn't be able to go get it, but if they go apply for a job or a background that's required, and then that would come up, then that would come up, they would be able to see it there, so, and they would not, if it's shielded, then could they, I guess I'm trying to clarify on how, would they never be able to get it expunged then?
So, I don't think that it would be a permanent bar on expungement, but the sense that I get from the judiciary is that it would absolutely pose a hardship in doing so.
It would be a lot more, and it could inadvertently create this hardship by being there because it's shielded from everyone except for certain people during background checks, certain businesses, or the like. Is that accurate?
Yeah, I think that's the one.
And is there, I guess, since we're down to such a narrow, just A, B, and C, I mean, is there, how do you, is there a solution to the judiciary's concern or the point of, is there a solution to do it to where we're not inadvertently impacting them?
So the only thing that I can think of on that point is if you were to specify in the language, I need to double check, this may actually already be the case, that the person who is the subject of the record could, is obviously not considered in the public for the purposes of accessing their own record at the courthouse. But I don't know that you could get around that. Most people are probably looking at it on case search.
Okay.
I don't know that you could get around it with the case search issue.
I don't want to take up a lot of time. I was just trying to think out loud about a solution.
You elucidated the problem, the issue with this, apart from implementation. But if Eric or Mr. Galley or Mr. Dews want to speak to this, is there a balancing that you all are, what's your response?
We know from the 14 states that have done it is that they have been able to do computer changes that first of all, you can, in most of the states, and we believe you can do it here, you can go to the court and petition to search for your record yourself. You could say, I am so-and-so, and I want to search my records, and that would be superseded here. We also believe that the attorney who tries the case often has the case file and has the information for this as well. What other states have done is they've just done different levels of access, and they've allowed you to basically, with a code, you can shield yourself.
So, Mr. Chair, would that be a policy change at the courthouse for that, or would that be something that we need to add in to mandate that the courts allow the person to do their own check at the courthouse? But they wouldn't be prohibited under the new language?
They would be able to go and get their own record.
You can go and get your own record.
And that, okay.
That's a self-driven process, and then part of the thrust of the bill is that once you are become eligible, it kind of automatically happens, relieving that administrative burden, taking time off of your day to go on to do this. So there's a burden on the individual to have to self-drive that process. But
to read from the statute. Yeah. So 10302 of the criminal procedure article does provide a list of individuals and situations where a shielded record is still accessible. And it does provide, among others, that the person who is the subject of the shielded record and that person's attorney may still access it at the, record, but they are definitely in the record.
what was the question?
So the question was with the...
Action,
okay.
There's been a motion for a favorable with the amendment. Do we need a roll call, or is everyone? All right. I'm folding this down. All right. Senate Bill 483 with the as amended passes 10-1. Senate Bill 810.
So Senate Bill 810 is a bill on which JPR is secondary, Triple E was primary. They voted the bill with an amendment, which is in your packet. It's number 923-923/1. So with the amendment, the bill is an emergency bill which prohibits most public school employees from engaging in immigration enforcement at the public school, and also prohibits them from providing information or documents to immigration enforcement about students or school employees and their families. If they're presented with a valid judicial warrant or subpoena, they would be required to contact the county superintendent or legal counsel, who would presumably be the one who resolves that situation. The amended bill also expands certain provisions related to sensitive locations from legislation that was enacted last year. So it expands the requirement that certain government-operated sensitive locations deny access to immigration enforcement agents without a judicial warrant to include areas for which a security screening is required. It additionally expands the definition of sensitive location to include a school bus stop, a school vehicle, as well as areas that are distributing food to people in need. And finally, the amended bill requires the Office of the Attorney General to annually update their guidance related to immigration enforcement at sensitive locations.
All right, I'm just going to ask if we adopt the amendment so we can work off the amended bill. Is everyone okay? All right. Now the bill is before you as amended. Discussion. There's been a motion for a favorable. It's been seconded. Just do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
No.
Senator Muse.
Yes.
Senator Folden.
No.
Senator James.
No.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Nay.
Senator Charles.
Nope. I'm sorry, yes.
Chairman Smith.
Is that a Freudian slip? No, okay. Yes.
Yeah.
Maybe.
Oh, there's four.
Yeah. All right. Passes 7-4 with the amendment. I have.
The fourth's gonna go on a little later since that's her time.
All right, let's go 937. So we are 937.
So thank you for sharing a copy of the amendments that came in. May I walk through them and the position on them, if I may? Yes, well, the proposed, I don't know that they're drafted as amendments, more so as comments from some opposition to the bill. The first one is on Bill page 5, and it's on lines 12 through 14. Lines 12 through 14 speak to a provision that makes the bill in compliance with federal code. It talks about federally assisted housing. There's a restriction that exists for federal housing dealing with methamphetamines. In the way that it was previously drafted, it's in compliance with that. But in speaking with advocates, adopting language that would expand the manufacturing to distributing or dispensing would certainly be agreeable for methamphetamines, but striking the qualification of federally assisted housing would not be agreeable because that language on lines 12 through 14 is specific because it is complying with the federally assisted housing. So the distributing and dispensing would be agreeable, but the controlled dangerous substance, all that other stuff would not. Going through, adding in so it has manufacturing, and then they put in a comma, and then distributing or dispensing, and then there was an amendment to add or producing, so it would just put those two other verbs in before the or producing. So it would be for a potential tenancy in a federally assisted housing, manufacturing, distributing, or dispensing or producing methamphetamine on the premises of federally assisted housing. So maybe strike one or, but adding those two qualifiers of distributing and dispensing.
I think the thrust of the amendment was to expand the consideration from just methamphetamine to cover a controlled dangerous substance or destructive device. So it would be a larger, the scope of the consideration would be larger than just methamphetamine.
So that's taken care of on the second page. So this portion here is the portion that you can disqualify someone or deny housing to them before you've given them a conditional offer. So these are the things that are just on its face when they first come in to apply. You don't have to see if they're creditworthy, if their income qualifies. If they have these convictions, you can deny them housing on the face. The second half of the bill is after they've gotten through the qualifiers to say that they have enough income, they're creditworthy, then you can look at the second slate of offenses. And the second slate, that's where you have any felony. So that's where your convictions of the controlled dangerous substance of the felony variety, that's where that would come in. So they still would have the opportunity to deny based on that, but it would just be after a conditional offer is made.
Okay.
And so the second thing that they have there is they have a crime of violence under 14.
Sorry to interrupt.
Sorry.
No. How does this interface with what we just passed for the?
With the income?
Yeah.
So for the federally assisted specifically, I don't know that looking at their income and looking at their criminal history would have any bearing. I don't know that the two would work together or apart. With the second one that they have there, it's a crime of violence under 14101. The crimes of violence under 14101 are handled either on the front end or the back end. So you see the enumeration of different crimes that are listed here, where the sexual offenses, everything under Title III. You see the child pornography listed there specifically. You see the murder in the first degree, murder in the second degree, human trafficking, sex offense registry. All of those offenses are things that they could deny housing on the face. So if you come in and you have any of those things, they could deny housing before having to do a conditional offer. Then on the back end, if you don't have any of those things, but you have a different offense, then what they would do is do the conditional offer, then do the criminal background screening. If they do the screening and they find that a person has a felony offense and they have it within the last 3 years, they could still choose to deny. But if that person is someone that, is creditworthy and income worthy, they could give them housing offer, but they could also deny, is what the second half of the bill does. But with the second half of the bill, that's where you're going to get all those other crimes of violence. What's particularly problematic, though, about their proposal is they want us to include other felonies under federal or state criminal code. When you include felonies under other state criminal codes, you have things like, for instance, in the state of Texas, it's a felony if you perform an abortion at a certain degree of gestation. So we certainly can't include into our state law that we could deny housing to someone if you're convicted of a felony under the laws of someone else, under the laws of another state. You also have the impracticality of landlords trying to search the laws of all 50 states and to search the criminal background of someone in all 50 states to figure out if they've committed a felony in all 50 states. It would just be impractical to enforce, and I don't know that they reflect the values that we have here in the state of Maryland. So for that one, we weren't able to find any parts of that that we could adopt because, one, the crimes of violence are either covered in the front of it or the back of it. So we didn't find any there. On the next one that they had, it was they wanted the statements to be offered under the penalty of perjury. And speaking with the advocates, they were fine with that. We understand that the landlords have a lot on the line. This is their investment. These are communities where we want people to be safe. So if these statements and applications are made under penalty of perjury and we wanted to interlineate that into the bill, that was just fine. What they also asked as well, there's another provision in there wanting to loop in felonies of another state. We would reject that. Another one to do that, we would reject that. They did ask for the look-back period to be expanded from 3 years to 7 years. 7 years is the existing law, so it would be not changing the law at all. But in speaking with the advocates, they did offer a compromise to do a look-back period of 5 years so that there was some additional relief from the existing law, but it would require an interlineation in the bill to go from 3 to 5 years. And then the next one that they wanted on page 7 was again under the penalty of perjury. They were fine with that. And then the next request that they made was on page 10 of the bill. On page 10, what they requested is that the portion of the law that puts it into the Consumer Protection Act, that be stricken. And the reason for that is because of the penalties provided in the CPA. So what we've proposed is that if the issue is not wanting to be subject to the CPA because of the penalties, we're totally fine to cap the penalties at $500 per violation, which is what's written into the bill. But you have to have some sort of cause of action and some sort of enforcement mechanism for the bill. You can't just strike it from the Consumer Protection Act and have no sort of vehicle to do enforcement on the bill. So we would be happy to say that it's still in Consumer Protection Act, so we wouldn't adopt their suggestion to strike lines 16 through 23 on page 10, but we would be fine with adding some language that says any violation thereof would be capped at a maximum penalty not to exceed $500 for each violation.
All right, let's just hold on a second. All right, so this is on the record, we got this. This is gonna be the first bill we do tomorrow morning, I promise, but this is too much. I don't know if you're recording, I mean, this is what we're gonna do is we're gonna pull people off the floor tonight to get this right, and this will be the first bill we vote tomorrow, okay? But I just, there's a lot.
Thank you, Mr. Chair.
No, it's a lot. No, I appreciate this is good, that's in the record, and this is, go ahead.
At the very end, at the bottom of the page, they wanted to make sure that this would stop a political subdivision from enacting a more onerous provision. You have a problem with that? This would preempt the field. Okay, great.
We're okay. 187. Josh.
Senate Bill 187 alters the specifications for the pre-release unit for women within the Division of Correction, establishes requirements for the Department of General Service relating to proposals for construction of the facility, establishes requirements for the contract awarded to build the unit, alters the requirements and timeline for the services that must be made available for female incarcerated individuals and requires certain progress reports be provided to specified legislative committees on compliance with the bill and construction of the unit. There is an amendment in your packet. It's number 593124/1. So the amendment renames the facility to be the reentry facility. It makes a change to who is eligible to be housed at the new facility. So under the current law, it's restricted to women who have the pre-release security status. Under the amendment, it would be open to women who are within 18 months of their anticipated release date and who have had no Category 1A disciplinary infractions within the previous 3-year period. Finally, the amendments would alter some of the requirements for the site of the facility. So it would alter the amount of acreage that the site is required to have, and it strikes from law the requirement that the facility not be located within a 1-mile radius of another correctional facility.
Okay, let's, can we go ahead and adopt the amendment, and then we'll, yeah. All right, now the amendments, now the bills before you. Yes, Senator McKay.
If you look on page 3 of 6, line 20, it talks about not less than, because we've now changed it to 2 and not more than 4 acres of land. I tend to believe that we're narrowing what is the scope. And since we've already decided that it's going to be located in a subdivision with the largest number of people returning that is likely to return, I don't understand why we are holding the boundaries of just between 2 and 4. And so I'd like to amend just striking line 20 from the bill.
What page?
That's page 3 of 6, line 20. I'm sorry? Page 2.5. I just want to strike line 20.
So that amendment's been seconded. Is everyone okay with being recorded in the affirmative on that amendment? Yeah. All right. Great, the amendment's adopted. Senator West.
Do we have a current fiscal note on how much this is going to cost the state of Maryland and taxpayers? What? What's that?
So I believe recent estimates from the department, and they can correct me, I don't know if they're here, but if they have, I think it was about $100 million to construct the facility is recent estimates we've had.
And how much has already been spent on the existing effort?
So I believe
Be abandoning?
about $9 million had been budgeted, of which I think about $350,000 had been spent on the planning phases of the project.
Okay.
Thank you. Well, that was one of my questions, was about the cost, but Josh, if you can help me out here, you spoke about Category 1A violations. What would that be? I don't know what that would be.
than 84 in the last.
The one thing that I wanted to say, and I've had an issue sometimes with agencies in the past when legislators pass laws and laws just are not implemented or executed as they should. Senator Washington had provided me with a timeline. So, I mean, just looking at the timeline, it was back in 2020 when we passed SB 684. So, I mean, this was over 6 years ago. And to try to make an argument that it costs too much now when the department, and I know that argument is coming from internally, but when a bill was passed or the law was signed or the bill was signed into law over 6 years ago, and really there's not much to show for it, I don't think you use that as an argument to kill a bill. The delay certainly was not on the part of the sponsor. And I just wanted to make certain that I said that for the record.
No, I wholly appreciate what you said. That's accurate. Senator Waltz-Reiger.
All right, so there was a reference made earlier to the number of people this impacts, and I just want to understand how that affects the change. So there was some wording change from pre-release status to all people within 18 months of their release. How many people are in pre-release status, and how many additional people will be eligible under the change that the amendment provides?
So I believe currently it's about, I think, 61 or 62 are in pre-release status. I don't know the exact number under the new language.
Well, I mean, can you just give us, I don't understand the substantive change. No. So is this something that's going to go from 60 to 120, from 60 to 1,000, from 60 to 65? Like,
I mean, it kind of depends on what people's disciplinary records are, because essentially the way pre-release status works is rather than being about a specific time until you're released, it's a security status that takes, I think, kind of everything about the incarcerated individual's case file into account, such as the offense they were convicted of, their disciplinary infraction. So this theoretically applies to individuals who have a different security status, but it depends on what their disciplinary records are, obviously.
all right, I understand that there's a desire to move this. I'm not getting in the way. I'm a supporter of the bill. I think I'm a co-sponsor of the bill. There seems to be some unreadiness. As we get this information, perhaps before we go to the floor, before the bill goes to the floor, could we get the numbers of people that will be newly eligible under the amendment and the change? And then how that alters the cost estimate? In other words, I understand that the cost estimate is capital, but ultimately you're going to have to build a bigger facility to accommodate more people under the new definition as you switch from pre-release status to 18 months. And so we'd have to get some kind of revised fiscal note to adapt to the new language and the new population.
Well, we've got the department here. If you'd like to come up and answer that question, if you've got it. Senator McKay, go ahead first while Jason's on his way up.
Well, while Jason's on his way up, Senator Charles, when you had said the department, were you inferring it was Department of Corrections Public Safety, or were you talking about multiple departments? Because
the testimony is multiple agencies, not just one specific department.
Thank you. I just wanted to clarify that.
Right.
I didn't want to hang out one.
No,
one agency over
the testimony seemed pretty clear that it was a bunch of agencies who had some role in this.
Thank
that's why I said the executive. Well, that's what I meant. I'm talking about the executive branch.
Thank you, sir.
Just to reframe the question, so you've got 60 or so people right now in the pre-release status, which is a security status, not a period of time. The question was then, if you have, what is it, 18 months or 16 months?
18 months.
So the new language calls for people for whom their term of incarceration ends within an 18-month period of time. How many people does that include?
Yeah, so under the, so Jason Davidson for the record, DPSCS. So under the amended version of the bill, so you're now changing the criteria for women that are 18 months, within 18 months of release. without those infractions, you're talking 48 total women that would actually be eligible. So it'd be 17 women in maximum status, classification, 25 in medium, 3 in minimum, 3 in pre-release. So 48, based on our preliminary numbers. I want to stress that we're doing preliminary analysis. We just got this yesterday, and it's a lot of changes. 48 total.
Okay.
So the women who, so with it, you add is that including the pre-release women?
Well, the bill as we're reading it, it's no longer pre-release. It's about any incarcerated individual at MCIW that would be within 18 months of release that don't have those infractions. So under those guidelines, we're talking only 48 women would be, well, I shouldn't say only, 48 women would be eligible under the new amended version of this bill.
It'd be 65 women.
Yeah, so under the, before the bill was amended, we had, the last count I got, which was, I think when we had the bill hearing, I think we were around 65 to 70 women that were in pre-release classification.
So now if we use this new standard, we're going to spend $100 million to build a facility for 48 women?
So under the amended version of the bill before you, right now, 48 women would be eligible.
Okay.
I'm still waiting on my answer for 1A offenses.
So the list is, so participates in a disruptive act, commits assault or battery on staff, commits assault or battery on an inmate, commits assault or battery on a person who is neither staff nor an inmate, makes threats that include the use of physical harm to objects, property, or individuals, possesses, uses, or manufactures a weapon, escapes when assigned to maximum or medium security status, escapes when assigned to minimum security status, possesses an implement or article that may be used in an escape, possess, misuse, tamper with, damage, or destroy security devices, equipment, property, detection or monitoring equipment, or fire suppression or alarm devices, in any manner arrange, commit, perform, engage in a sex act or sexual conduct.
Josh, I appreciate it. I mean, that gives me an idea. I mean, I was just curious if it was like really severe infractions. Sounds like that's not the case. So it's pretty broad. So just want to be clear then, $100 million to 48 people, 48 women currently would be eligible. I just having a hard time swallowing this idea of spending $100 million when we are facing a deficit and out years are looking even worse into the billions of dollars. And for something, and I'm not disagreeing with my good friend from Baltimore who's saying that there was some inaction by some of the other agencies, you know, during the previously passed, legislation. I'm not going to dispute that, but we're in wholly different times now. So, but I appreciate you coming down for the answers, and thank you, Mr. Chair.
I first heard about the amendments. It never occurred to me to ask you this question, but now it does. I figured that with us getting out of, and thank you for being here, and thank you for all your good work. When we got out of pre-release and we got into this new word pre-entry, that would actually open up the number. So like if we were at pre-release at 60 or 68, that if we opened it up to re-entry and it went back 18 months, we would have encompass a potentially larger group. Give me a succinct answer as to why this group, other than people who have graduated or left prison, why has that group of 60 to 68 shrunk down to 48 just with what we've done in the bill?
Yeah,
Real
so,
briefly.
Thank you, Senator, for that question. Yeah, no, thank you for that question. Yeah, so because we're no longer under the bill before you as amended.
Right.
We're no longer talking about incarcerated individuals at MCIW that are in pre-release status. We're now talking about all women. And when you take in the Category 1A infractions within a 3-year period, that reduces the number.
So, so forget pre-release. It's not like pre-release plus, let's add some people that we're now calling.
The way we're reading, the way, again, I want to stress.
Yeah, no, I get you, but, so I had read it because I didn't no one let me see the amendments in their entirety. They just talked me through them. But, so I thought it was the category we had, then we added some language. Instead, we have subbed out that language, which was concrete, that pre-release language. We knew who was eligible for pre-release. We knew what the number was. Now we're in a new language of reentry, and we have some, and then we describe or define what reentry is. There's infraction, are make you eligible. That's wonderful. But and so that then with that criteria, it's a different population. Potentially, there may be some overlap, but it's certainly now a smaller population.
Under the bill as amended?
As amended,
Yes.
with these amendments, which we
Yes.
have not adopted.
Correct.
So thank you. All right, that's interesting.
All right, just before we turn it over to McKay, okay, so pre-release status, you have 60 or so women in that security status. And then with the new layering of the requirements for this new facility, there's got to be overlap between pre-release status and women that qualify under the bill. Is there overlap, or is it in addition to?
I just asked.
My understanding is that only that number would apply because you're talking, the bill has been amended down to just 18 months.
Yeah, so if I asked you if we were to make an amendment, right, to say, and pre-release status women, like that number would probably be subsumed into the number you gave us, or would it be in addition to?
Well, if you added, you'd have to adjust the 18 months. You probably would have to make some adjustments to the 18 months, then the category 1 infractions in the 3 years, most likely.
So would there be overlap, or?
I would, again, I'd have to see the exact changes you're looking at and then take it to my policy team and data team.
Let's assume there isn't any overlap.
Sure.
So the number you gave us was what, how many?
48.
Plus 60.
Right now, there's between 60, latest count I saw.
So we're looking at a maximum of like 120, 130 women if we added pre-release and it were not included in the number you gave us.
Yeah, rough math, yes.
Okay. Senator McKay.
What about those maximum? What is the census of those who are, I mean, how does that apply?
Well, incarcerated women in maximum security status would be eligible under the bill as amended to go to the new facility.
Really?
Yes.
Under maximum?
Because they would be, as long as, if they're within 18 months of release, which is the way I'm understanding the bill, they would be included. I'm sorry?
Yeah, from release date, mandatory release date. Of the mandatory release, because they wouldn't have had a program that says 18 months out. That's right.
It's the language says anticipated release date.
So would that be?
So I'm going off of the anticipated release date.
Mr. Chair, I think in light of getting this right, and we've got to get to the floor, can I ask this to be held? Okay.
Just to get the definition right, we'll get it right. We will get it right.
That's important information we need to know. Thank you, sir.
All right, now we're going to go on to Senate Bill 626. Josh.
Senate Bill 626 repeals the requirement that a licensed healthcare practitioner determine that an individual's sex designation should be changed for the purposes of issuing a new birth certificate. Instead, the individual, or if they're a minor, their parent, guardian, or legal representative, would have to make a written request under penalty of perjury to the Department of Health for a new birth certificate with a sex designation that differs from their original birth certificate. When issuing the new birth certificate, the Secretary of Health must allow the individual to designate the sex of the individual as female, male, or unspecified or another. If an individual indicates unspecified or another, the Secretary must ensure that the new birth certificate displays an X in the location indicating the individual's sex. The bill also alters certain provisions related to issuing a new birth certificate due to a name change of a listed parent.
Motions for a favorable. All right, roll call.
Sure. And how did the name change part? How does that, what is the premise behind that name change of the parent?
So there. So there is existing law that allows you to alter a birth certificate to based on the fact that a parent's name has changed. So this is
So that's
making.
consistent.
Yes, so that's making some
not new
changes
bill.
to that.
Okay,
yeah.
thank you.
Vice Chair Waldstreicher.
Yes on the favorable.
Senator Sidnor.
Yes.
Senator West.
No?
Senator Folden.
No.
Senator James.
I'm going to put this on the record. I'm going to vote yes on this bill based on the representations from the Senate President's office, that some issues that I brought up with this bill that are very legitimate and that they understand and acknowledge, and we're working on some language. And my understanding is we're going to have a House version of this bill, Mr. Chairman, right? Well, there is a House version of the bill. Okay, so, and then that would be an opportunity for us to delve a little deeper into, this has to do with academic research, medical research, scientific research, and the like. So for those reasons, I'm going to give a qualified yes. Thank you.
Senator Henson. Oh. Senator Love.
Yes.
Senator McKay.
So I want to say that from the Senate President's office, I agree that the explanation, like calling balls and strikes, made a whole lot better sense than what had transpired and all that kind of stuff. So I wish we had been able to insert that information. That being the case, I'm a firm believer that a certificate is a certificate, not a resume, and I don't believe those things should be changed. So I'm a no.
Senator Charles.
Yes.
Chairman Smith.
Yes. Final call is 7-2.
That's not right.
Sorry. 6-3.
6-3. All right, that's the last bill we're going to encounter today, so see you all on the floor.